How will a modified comparative negligence affect an auto injury case in Connecticut? Attorney Donald Beebe says, the expression modified comparative negligence is not used in Connecticut. However, there is a law that indicates that fault is allocated amongst the people who are responsible for the injury. A person who has been injured by another can recover, even if he or she has been negligent, as long as their negligence is less than half of the total negligence that occurred. In other words, if a person is a passenger in a car and are rear-ended, they are not at fault at all. There is generally no way that they could be at fault. That would mean that everybody else who could possibly have caused the injury are 100% at fault, so there is no comparative negligence. Taking the example, if the driver of a car comes onto an intersection where they have a stop sign, they look both ways, and they see a car coming into the intersection from some distance. They have a right to assume the car is driving at the speed limit or less, and they pull out. If they misjudge it, they may have some comparable fault with the driver of the other car if it turns out that they saw him but misjudged the fact of how fast they were speeding. As long as the other driver was 51% or more negligent, the injured party can collect. This does not apply to the passenger who would have no comparative negligence, but the driver might have some. The way comparative negligence affects the case ultimately is if, for example, the person who was injured is 25% at fault and his damages are $100,000. The court will reduce the damage claim by $25,000 for his portion of the damages. That is the simplistic answer to give an idea of how this works. For a free phone consultation, contact Attorney Donald Beebe in Norwich, Connecticut at 860-889-5266 or visit his website at www.beebeandoneil.com.